Good morning, everyone. Who has announcements? Anything to share? All right, let's hear it, Ms. Miles.
So yesterday, my mom was talking to my neighbor, like a few houses down from ours, and she told my mom the year before she moved into her house, there was a murder that took place in her house. She moved in her house in 1986, and then the murder took place in 1985. And the murder was a guy who killed his whole family. Um, and this actually made it all the way to the Georgia Supreme Court. The second go around it did, but he killed all of his family, and the first go around they dismissed the case because he had evidence saying that, well, here's a receipt from Kmart, and it says I was at Kmart at the time of the murder. So basically what he did is he went to Kmart, and the cashier was like, oh, you're really, really sweaty. Are you okay? And he was like, oh, yeah, I'm just buying a fan. And the Kmart associate told the police, oh, we keep our store very, very cold, so it was impossible for him to be sweaty. Basically, he killed his family right before he went to Kmart, and when it went to the Georgia Supreme Court the second time around, that's when they figured out, oh, the times are wrong. He already killed his family. But yeah, he killed his pregnant wife. She was 8 months. His 4-year-old daughter and his 20-month-old son. And they called him the Bush Axe man because he killed them with the Bush Axe. And if you want to look up the story, his name is Michael Curry. Just type in Michael Curry, Columbus, Georgia, and then click on Michael Curry found guilty, Columbus Ledger Inquirer, and just like read the whole story.
Nice.
Yeah, I was like, I'm gonna bring this up in class because it's a business class, and I'm like, this would be pretty cool.
Thank you, Ms. Miles. I am going to check that out. So, did the murder happen in your mom's house or the neighbor's house?
No, the neighbor's house.
Okay. Would that freak you out if it happened in your mom's house?
Yeah, that would freak me out.
Yeah, that freaked me out too.
I'm like, I don't even be in a house that.
Yeah, I'll be like, somebody that should have been disclosed before I bought this house. So did he not go to trial the first time?
He did, but he kept playing off of that. I have evidence if I was at Kmart, like while the murder was happening, and he staged the house to look like it was broken in and they killed his family.
Dang.
But they went off only a dad will have the motive to kill his 20-month-old son.
So I'm definitely going to check that out. And what I'm interested in is we know that constitutionally you can't be tried for the same crime twice. So there's some way that the state got around that.
Yeah.
That I'm be curious to see how they did. So
it tells you like more stuff. You just have to read it if you want to.
When did the second Supreme Court case get decided?
Is that what?
When did it go before the Supreme Court the second time?
May 20th, 2009. So it happened like 25 years after like he got the first time around.
So did he? So he's been free. He was free all that time, and then they tried him again, and was found guilty, and now he's in prison.
Mm-hmm.
Wow.
I don't know if he's dead or not. I would assume so, but yeah.
Okay. Well, thank you. That's a great case. Thanks for bringing that up. Anybody else want to follow that up? No? Nobody has anything else to say? All right. That's excellent. Definitely we'll look at that. All right. So today I'm going to finish out the lecture for this week. We're going to talk about alternative dispute resolution. And then we're going to do a short little fact pattern that illustrates steps in a case. And then I may, if I've got time, talk about a couple of current events. You will have a quiz due Monday. I'll post it later on today. It'll be over this week and last week. It's multiple choice matching true false, just like last week. Anybody have any questions on where we are? All right, good. So alternative dispute resolution. ADR is important because it is heavily used by the courts in modern times. It's maybe 40 years old. It was a new thing in the 80s. Now it's become routine and commonplace that most cases will settle using ADR before they actually get to trial. There are three different main areas of ADR that I want you to be familiar with. We got you a seat, Davis, if you want it. You don't have to. Yeah, I want you to sit there because you feel obligated. They are negotiation, mediation, and arbitration. Your outline says 95% of all cases that get filed get settled by one of these methods without ever making it all the way to a trial. That's good for the parties in a case. It means they've both agreed to resolve the case in a way that they can live with, they're each happy with, or if not happy, at least can live with, like I said. And it means that the courts are not overly burdened with cases. Well, they're already overly burdened with cases, but they're not more burdened with having to litigate 100% of the cases that come before them. So most cases settle before they go to trial. They settle through alternative dispute resolution methods. Negotiation. Negotiation could happen from before a lawsuit is even formally filed all the way up until after a case has been decided. And here's how that can work. My neighbor has a oak tree that falls onto my property and crushes my car. Then I could sue them in a civil case to recover the damages to my vehicle. But there's nothing stopping me from picking up the phone and saying, hey, your tree fell on my car. This is how much it costs to fix it. Would you be willing to pay for that? Negotiation. They might say no, yes, kiss my butt, see you in court. Who knows? But there's nothing stopping me from doing that. Once I file the lawsuit, there's nothing stopping the lawyers from calling each other and saying, hey, how much do you want? I want $20,000 because that's what it costs to fix my car and my fence. We'll give you $10,000. No, I want 20. How about 15? There are no rules that dictate how or when parties can negotiate. You're always free to do that. The advantage of that is, wouldn't it be easier and better for my neighbor to just write me a check beforehand before I even have to go hire a lawyer and go to court? Sure, that'd be wonderful. I might even take less than the $20,000 that it cost me to repair my car just so I can go ahead and get it paid for now, and I don't have to go hire a lawyer and go through the expense of a court case. Negotiation is always possible. Most of the time, I think that negotiation doesn't take place up front or at the very beginning of a lawsuit because the parties are more emotionally charged and mad at each other. I did a lot of divorce litigation, and I know that's not business law, but it lends itself really well to explaining some of the things we're talking about. Man comes in and hires me to file for divorce from his wife, and I pick up the phone and ask her lawyer, hey, y'all ready to settle? Most of the time, they're going to tell me to go jump in the lake, right? As a case progresses, maybe we do discovery and we find out what all the assets are. We find out where the kids want to live. 6, 7, 9, 12 months into the case, it's a lot easier for me to pick up the phone and say, can I send you an offer? Here's what we offer to settle the case. A lot easier to do the longer a case goes. Not only are tensions and emotions lower, but each party knows more about the strengths and weaknesses of their case. So their negotiating leverage is different, often very different 10 months into a case than it is at the beginning. Maybe the parties have spent so much money on lawyers already, and they're haven't even gone to trial yet, that they're just like, just get me out of this. I just want to be done. Negotiation can happen during a trial. I've seen instances where parties go to trial. The trial is not going very well for one side. They walk over during a break to the other lawyer and say, would y'all take this much? I'm gonna up my offer. I'm gonna change, my leverage has changed based on the performance of my witnesses and things that have gone on trial to the point that now I am willing to pay you what I maybe wasn't willing to pay you before. Negotiation can even take place after the trial. Here's a great example of how that works. Do y'all remember hearing about, because y'all are all too young, but do you remember hearing about the lady who sued McDonald's when she spilled the hot coffee in her lap? If you don't know about that case, she was riding shotgun in a car through the drive-thru at McDonald's. Her nephew or grandson was driving. He handed her the coffee. She put it between her legs so that she could take the top off and put in creamer and sugar or whatever she's going to do. And it spilled backwards toward her. She was wearing gray sweatpants that soaked up the coffee and held it against her skin. She had like third-degree burns. Ended up having to go to the hospital. She had like $20,000 in medical bills. She sued McDonald's and asked for $20,000. McDonald's told them to go jump in the lake. They went through the whole pretrial process, couldn't settle the case, got all the way to trial, and the jury gave her $3 million. So that was a oops moment for the McDonald's lawyers, right? They could have made this go away at the beginning for $20,000. Instead, it made headlines around the world, and she got $3 million. But that wasn't the end of the story, because McDonald's had some grounds that they thought they could appeal the case on, which is their right to do, and which we know from our discussion, if they appeal, that's going to drag out the case. The lady didn't get her $3 million in her pocket at the end of trial because McDonald's was going to appeal, so the case was still not resolved on a final basis. But their negotiating positions had changed significantly. She had a jury verdict for $3 million. All right, so McDonald's leverage had gone away on that. McDonald's only leverage that they had left was, we could drag this out through an appeal. If we win, we might have to come back and redo the trial, and you might not get $3 million. You might get more than $3 million, but you might get nothing. All right, so that was the negotiating posture of the parties. So it did end up settling after trial, but before appeal, for I think an undisclosed amount. But the way that went down was probably McDonald's picking up the phone and saying to her lawyer, hey, we're going to appeal, but we would be willing to not appeal if she would accept X amount, $1 million or $2 million. And then her lawyer would have negotiated back and said, we would do it. Whatever the number is, they came to an agreement. That ended the case. McDonald's couldn't appeal. And then she did get a check for whatever it is they settled for. It wasn't the $3 million. So that's how negotiation can play out even after a case has gone to trial. Mediation is the second alternative dispute resolution method I want you to be familiar with. And mediation has become so popular in the court system that almost all civil cases, not criminal cases, all civil cases are required to go to mediation before you can go to trial. It's like getting your golden ticket to go to trial. You have to try mediation first. Mediation works like this. A neutral mediator is selected. It's usually a lawyer, but it doesn't have to be a lawyer. The mediator is unbiased. The mediator doesn't know the parties. The mediator is not familiar with the case beforehand. The mediator is somebody that the parties have agreed to choose. A mediation is set up. The parties appear in one building together in a conference room. Used to be always in person. Now we do a lot of mediation by Zoom. I think in person is more effective, but just the way of the world. So the parties show up, the mediator will say, okay, we're here to mediate this case. Tell me what kind of case it's about and what are the issues that y'all disagree on. So in a divorce case, I used to do a lot of I used to be the mediator for a lot of divorce cases until I just got tired I couldn't listen to it anymore. And I would say, okay, it's a divorce case. Do y'all have kids? How many? Do you agree on custody? Who are they going to live with? Have y'all agreed on visitation when they're going to go see the other parent that they don't live with? Um, have y'all agreed on Christmas visits, summer visits? Have y'all agreed on child support? Have y'all agreed on alimony? Have y'all agreed um, how you're going to split up the bank account, the retirement account, all that kind of stuff? So before we actually get into the meat of the mediation, I've got a list of what the issues are. Then the parties will separate and go in separate rooms, and the mediator will go back and forth, basically taking offers and counter offers. And I would keep doing that. The mediator will keep doing that until there's nothing left to negotiate, or the parties have just come to an impasse where they are not able to, they just agree to not agree. Now, the mediator is more than just a messenger. The mediator gets to hear each side when they're in private conference with the parties. So in a divorce case or in the McDonald's case, I might go in with the McDonald's lady and say, what is your offer? Our offer is we want $50,000. Okay, tell me, how do you break that down? Because when I take it to them, I want to be able to explain to them how you came to that number. And they might say, well, $20,000 in medical bills, 10,000 pain and suffering, and then 10,000 we want to help pay our attorney's fees. I go to the other side. This is what they're asking for. McDonald's can say yes. Very, very rare for me to take an offer in to where the parties accept right away on the first go round. But I might say they're asking 50, and here's how they came up with that. She's asked for this, and this. This is the evidence that they have on that. And that helps McDonald's then formulate their counteroffer. And I would keep going and doing back and forth on that until if we settled or we just agreed we weren't going to settle. I would say that most of the cases that I mediated didn't settle at mediation, but they ended up settling before trial based on the framework that we laid at mediation. So imagine that you're in a dispute. Let's go back to the divorce for a second. Got filed. We did discovery. We're rocking along. And neither party has engaged in negotiation between the lawyers, so we don't know what the other side wants. We don't know what the other side's willing to give. We get to mediation, and the first thing that happens is I'm taking a written offer from one side to the other. So for the first time in the case, possibly, they're learning what it is that the other side would accept to settle. It's hard to settle when you don't know what the other person's asking for. So you learn about the other side's position, what it is they want, what their rationale is, what they think they can prove. And you're able to make much better decisions about whether or not you're going to settle the case based on what it is you think they may offer or accept. That makes sense? It is very helpful that at the end of a mediation, if I'm not the mediator but I'm the lawyer, I can sit down and say, all right, this was their final offer. We don't have to take it, but here's where I think your strengths and weaknesses are in your case. Here's what I think a judge likely would do. I can't predict it with certainty, but I've done this enough in front of this judge to sort of know how he or she operates. Here's what the law says. Here's what I think you would gain by going to trial. And the client can then say, all right, maybe I'll get a little better deal at trial, but am I willing to accept this less better deal to nail down some things and to be done with it? That's a lot easier for a client to process and make a decision on than at the beginning of the case when we don't know where anybody stands. So mediation gives the parties a preview of what the other side wants. It gives them an opportunity to settle the case. And perhaps most importantly, it gives them the chance to settle it on their terms. Okay? If I get an offer from the other side that's acceptable to my client, we settle the case. She gets what's in the settlement. We know for certainty the outcome of the case. If we say no to that and we go to trial, we don't know for sure what's going to happen. It's going to depend on the judge or the jury. I can predict with some certainty how cases generally play out like that, but I can't predict how good a witness my client's going to be. I can't predict with certainty exactly how they're going to, what evidence they're going to have. I might have done some discovery, but I might not know everything everybody's going to say. So in other words, the client has to weigh the concrete offer that they know would settle the case that they could decide on versus going to court and being completely losing control of the outcome. Okay, once you get it and put it into the judge or jury's hands, if the judge comes back and says custody of the children is going to be with dad and mom's going to have to pay him child support. But at mediation, dad was willing for mom to have custody and pay her child support. Too late. That deal's no longer on the table because the judge made a decision. So mediation, again, puts the power of resolving the case back in the hands of the parties. That does take two to settle, obviously. But it does put control of the outcome back on them rather than on the court. That's a reason, another reason that mediation is so successful. A lot of times we don't need to go to trial to settle something. We just need to get in a protected, safe, neutral space where we can negotiate in good faith with the help of a mediator. As a mediator, I could not make any decisions or rulings. I couldn't tell anybody that I think you should take this deal. I can't twist your arm and say you need to do this. You just need to agree. I can't do any of that. But I can help the parties along by saying, look, this is where they're coming from. I've spent 3 hours with them today. This is their position. These are the reasons that the reasons behind their offer or their position. And if you go to court, how are you going to fight that? I like a lot of times we'll have people say, well, I want $1 million a year in alimony. Okay, well, at mediation, I can say, well, can you help me understand? Remember, they're separate rooms. How are you going to prove that at trial? Your husband makes $50,000 a year. You have no savings. He doesn't have $1 million. So how do you realistically think that's something that you might get at trial? Help me understand where you're coming from. And a lot of times you can help the clients see kind of maybe the holes in their position or the advantages or disadvantages of where they're coming from. I can't make decisions. I can't tell them what they ought to do, but I can help do some reality testing and maybe move them along to help them appreciate where they are in the case. Maybe somebody is just being completely unrealistic. And when they get asked the question, do you really think that your judge has been a judge for 15 years, she's heard cases like this over and over. What makes you think that this time she's going to award you $1 million in alimony when he doesn't even have $1 million in asset? Explain to me how that's even realistic. That's an extreme example, but that's sort of how mediation works. The mediator cannot be called as a witness at trial, and that protects the party's ability to negotiate. I'm not going to be straightforward with the mediator if I know that the mediator could be called to trial and testifies to what I was willing to settle for, right? Mr. Mediator, at mediation, how much was she going to accept in alimony? Well, she was going to accept $50,000. Now she's asking for $1 million. Yeah, I don't know where that's coming from. Mediators are not involved in trial. That way the parties can feel free to negotiate and not worry that something's going to be used against them later. Mediation. Arbitration is different than mediation in some important ways. An arbitrator does make a decision. At the end of the arbitration, if the parties not agreed on anything, the arbitrator will say, okay, I issue this decision. It's called an award. Arbitrator makes an award. It's akin to if the judge made a ruling, if the jury issued a verdict. The arbitrator writes a written award. Arbitration is like a mini trial. It's a lot less formal than a trial. You're not in a courtroom, but you can call witnesses. You do ask questions of the witnesses back and forth. You do have to present evidence, but it's in a lot more informal setting. I loved arbitrating cases for a couple of reasons. One, I could get into arbitration a lot sooner than I could get before a judge in a trial. That is a huge selling point for my clients. We could wait 2 years because trials are scheduled based on age. Only the oldest cases get to get, you can't jump in line. So we're just going to have to wait our turn. And I can't predict for you when that'll be. But I can tell you that if we agree to do arbitration, we could probably get an arbitrator to hear this case. Today is September 4th. Probably sometime October or November, we'd get an award by December and you could be done. I also liked arbitration because I could pick an arbitrator that was an expert in the subject matter that was the subject of my lawsuit. All right. I mentioned to you earlier in my example about the judge being a judge for 15 years and having heard millions of divorce cases. Well, I also might draw a judge who's brand new. And that judge that's brand new may have come from, maybe he was a criminal defense. She was a criminal defense attorney. She doesn't know anything about divorce law. She's heard a couple since she's been a judge, but not a lot, doesn't have a lot of experience in it. I'd much rather have an arbitrator who knows divorce law backwards and forwards and who has seen a bunch of these make my decision than this judge. That'd be an advantage for me. If thinking about this construction that's going on, some of y'all probably know, and I don't know the exact details of it, but the brick wasn't affixed correctly or something. Does anybody know more about this than me? Y'all know what I'm talking about? Problem with the way that it was constructed, the construction firm is not in business anymore, so we couldn't sue them. We're just having to pay to have it redone. But in a construction lawsuit, we're going to be talking about blueprints and best practices in construction. We're going to have expert witnesses in construction talk about adhesives and materials and building practices. That's already going to go over my head. It's most likely going to go over the head of the judge, who doesn't have any experience in construction law. And it's damn sure going to go over the head of the 12 citizen jurors on the jury. Right? I mean, if I get called to be on a jury for a construction lawsuit, I'm not going to understand most of what's been being said. I would much rather have an arbitrator who does nothing but arbitrate construction litigation. Probably somebody who either did it as a lawyer, does it as a lawyer now, was in the construction industry, understands all this. That makes it so much easier. So much easier. The arbitrator can also be a little bit more active in how the arbitration is conducted. And by that I mean, we're in a conference room, one side on this side table, the other side, I'm at the end, I'm arbitrating it, and they start giving a testimony about somebody's IRA. And I'm like, hold on a second. Which IRA are we talking about? Oh, okay, the Vanguard IRA. Can y'all send me that? Give me that statement again. Remind me again how this happened. All right, now you're saying this. I can be a little more active, whereas a judge is more passive and really only can listen to what's being told to him or her. The judge does ask questions, but the judge doesn't get overly involved in the conduct of the presentation of evidence. At arbitration, we throw some of those formalities out because the arbitrator just wants to get to the bottom of it. It's a lot easier for complex cases. in my opinion, than having to trust maybe a judge who doesn't have any experience in that area, but certainly a jury who is very unlikely to have any expertise in that area. I would also like to have an arbitrator if I have a case that's particularly that has bad facts or emotional facts or some really, really inflammatory evidence to it, like in a medical malpractice case where maybe a doctor has messed up the delivery of a child at childbirth and it's resulted in some really bad outcomes for the child. I don't want to go in front of a jury on a case where a baby's been injured or died, because that jury is going to be, I'd rather be the plaintiff's lawyer so I can play that up to the jury of how bad this is and have that influence their decision. I would rather have an arbitrator who does this all the time, who's maybe a little more numb to it, who's less likely to be influenced by emotion, who views it more as a business transaction, like, yes, this is bad, this happened, but we've got to compensate the victims for what happened, but we don't have to let our emotions run away and award some crazy verdict. I might rather have an arbitrator in that case. If I'm on the side where I have really good facts and the defendant did something wrong, I'd probably rather be in front of a jury where I could play that up and use that to my advantage. You all are, I would be willing to bet that everybody in this room is subject to an arbitration clause in a contract that you have signed or a user agreement that you've agreed to. All right, we all click through, right? If you don't click the box that says you've agreed to the terms and conditions, they won't let you go to the next page. So we click the box, right? Anybody read the terms and conditions? You do, Scarlett? Good. Because you're a better person than me. You read it, Leandre? I don't read it. But a lot of times what those say are that you're agreeing, if there's a dispute between you and the other party, you're agreeing to go to arbitration and to give up your right to go to court. That's profitable and not profitable. That's advantageous for the company. It's cheaper for them. It doesn't result in bad publicity. It doesn't have the risk of some crazy runaway jury verdict. It's cheaper for the company to do that. So that's why they put that in all these agreements that you and I have signed. We are forfeiting our right to go to court and agreeing that if we have a dispute, we're only going to do arbitration. That's not always bad for the consumer. My beef with that is that the consumer really doesn't have a choice. I mean, I guess if I'm downloading an app and part of the terms and conditions for me getting a username and getting a counter, I've got to agree to go to arbitration. My choice is don't use the app or agree to arbitration. I mean, I do have a choice, but then I don't really have a choice at the same time. I can't negotiate that. I can't call up Snapchat and be like, hey, I got a couple problems with that user agreement. Can we talk about those and tweak that before I sign anything? They're going to laugh. The other advantage of arbitration for a big company is that the ability to appeal from arbitration is limited, whereas your ability to appeal from a trial court and the court system is not. So you'd be short-circuiting yourself a little bit. That makes sense to everybody? Arbitration, mediation, negotiation. You'll probably come across all of these in your careers if you haven't already. A lot of landlord-tenant stuff might have arbitration clauses in it. Did you make it, Keyshawn? Did you make that shot? You used to? You did? Good. All right. I think if there's anything else I wanted to talk about on ADR. I think that covers it, but let's be sure. The color of today's lecture is pink. Everybody got that? Write that down. Color of today's lecture is pink. All right, I think that's everything I wanted to talk about on ADR. Pull up, if you will, from this week's content, the document that's titled Fact Pattern for Class 9-2. All right, the purpose of this exercise is to go back through a court case from start to finish, a civil court case from start to finish, in the way that we discussed on Tuesday. So just going through some of the steps with a real live fact pattern. Just to sort of fact pattern for class 9.2. Does anybody not see it? You got it, Miss Miles? Okay. Fresh Mart is a grocery store in Columbus. On a busy Saturday, an employee mops up spilled olive oil in aisle 3. They put a caution sign at one end of the aisle, but not the other. 15 minutes later, Miss Johnson, small business owner, enters from the unmarked end. She slips and falls. She fractures her wrist, sprains her ankle. She incurs $18,000 in medical bills. She loses about $12,000 in lost profits because she can't run her flower shop during prom season. She sues Fresh Mart for negligence. She's asking for $50,000. All right, how do y'all break down the $50,000 she's asking for? Garrett.
The medical bills
are what? 18, all right.
Loss of profit total.
All right, that gets us to 40. So what's the other 10?
30.
That's it. That gets to 30. My bad.
And I guess 20,000 from suffering.
Pain and suffering. Good. Just out of curiosity, how are you gonna? What kind of evidence can you put up for pain and suffering? For a medical bill, I can put up what the hospital charged me, right? I don't have to guess on that. For pain and suffering, what kind of evidence would you expect? All right. So hold on. What'd you say first?
Like mental stuff, like mental trauma.
What kind of evidence would you want to put on for mental anguish? Witness testimony. Say that again. Yeah, maybe she had to go to a psychiatrist, and the psychiatrist can testify how messed up she was by this. Maybe she got prescribed anxiety medication that she didn't previously have to take. Who was the next? Garrett, you said the next one.
I was thinking like if it was for instance like really bad, the nature of it.
Oh, yeah, there you go. Right, it'd be great if she showed up limping, or in really bad, wheeled in a wheelchair, right? Yeah. Pain and suffering. That was good, Garrett. That's good. Leandre, what'd you say?
I was going to say something that shows that she actually went through it. So she had gotten depression from it, not being got sad. It's going to show.
I went to see a psychiatrist.
Yeah.
Maybe her husband testifies that she wouldn't get out of bed most days. I don't know. These are things that you might use to prove pain and suffering. All right, so she's asking for $50,000. If you go down to the next part, Fresh Mart's defense, okay? So they're not just going to say, if they said, yeah, this was our fault and we should pay for it, then we really don't have much of a court case. Their defense is going to be something along the lines of, it happened. We can't control that it happened, but once it did, we cleaned it up as fast as we could. We did what we were supposed to do. And oh, by the way, even if you find that we were a little bit negligent, she was just as negligent as we were. She was on her phone, not paying attention to what she was doing. So even if you find us to be a little bit responsible, you need to knock down whatever awards you find for us, because she was responsible too. That's kind of fresh mark's defense. All right, so we would next go to the step of jury selection. Jury selection works like this. The state or county will issue summons. Anybody ever been getting a jury summons? Who's been on a jury? Nobody's been on a jury? All right, Austin, did you have to show up? And did they ask you questions?
Never made that far.
You didn't make it that far. Okay. Who did?
I had jury summons, but I wasn't on an actual jury.
You got, okay, they didn't actually pick you. So the judge might call down to the jury room and say, send me 50 jurors, potential jurors. Then the lawyers get to ask questions to the potential jurors. And the lawyers can strike them for cause. They get to strike a certain number for cause. And that means for a good reason, like Leandre is cousins with the defendant. If I'm the plaintiff's lawyer, I'm striking Leandre for a good reason. You also get a certain number of strikes that you can use without giving a reason for. And lawyers will use those they'll use those maybe if I'm in a divorce trial and I'm representing the husband and there's a lady in the jury pool who just looks like she hates men, I might strike her but not have to say that's why. So you get a certain number of those. All right, so you guys, these two rows are lawyers for Freshmart. You 2 rows are lawyers for Miss Jackson. Miss Jackson's lawyers, what kind of questions do you want to ask the potential jurors? What would it be important for you to know about them before you decide whether or not you want them on the jury?
Do they work at, like, do they have any previous employment to Freshmart?
Good, Scarlett. You ever work for Fresh Market? And as a follow-up to that, how was it? If they loved working for Fresh Market, you definitely don't want them. If they're like, I worked there, but I got fired, then maybe we do want them on the jury. Conversely, you guys don't want anybody that you fired on the jury, correct? Probably not. What else do you want to know?
It can also just be people who like shop there and then had a bad experience as well.
Yeah.
Like
Do
someone that was
you shop at Fresh Market? What's your opinion of Fresh Market? Yes, sir.
Like if they know anyone personally that works
Yep.
and manages the store.
Yep. Do you know anybody involved in this case? Miss Jackson's, no, you guys are Fresh Market. What else do you want to ask potential jurors? Yes, sir.
Do they have any relation to Mary?
Yep. Y'all related to Mary?
Has the Bureau ever been involved in a slip and fall lawsuit or workplace accident or anything like that?
Has who?
The jury? Like, have they
Yeah.
been involved?
Yeah. Have you guys, has any of you ever sued a company for slip and fall? Any of you ever been hurt at a store before? Any of you ever broken your wrist? That is one of the biggest questions I would ask. I knew a lawyer one time who had a slip and fall case, and he didn't do a very good job of vetting his client and asking good questions and preparing for trial. And when they got to trial, it came out and was a surprise to him that she filed slip and fall lawsuits all the time. They lost that case fast. So that's a great question. What else? What other questions might y'all want to ask?
How do we do any of them own business?
Yeah, any small business owners in here? They might be more sympathetic to your client, right? Good. So those are the things that would go through your mind as you're questioning the jury. Once the jury gets picked and seated, then the next step would be for the lawyers to give their opening arguments. You're more familiar with this kind of stuff and from Law and Order and your TVs and movies and things. The lawyers would stand up and tell the jury what they expect the case to be about. Ladies and gentlemen of the jury, and what they expect the evidence to show. So maybe if I am, I skipped some stuff. I skipped discovery altogether. My bad. Let's go back to that. What are some things that you want to do in discovery through depositions, interrogatories, requests for production documents? Mary's lawyers, what do you guys want to see or ask for? Yeah, give me your camera footage. Could be good or bad for you, right? But you definitely want to see that. What employees do you want to talk to at Freshmark? The manager, the cashiers, the one who cleaned up the mess, right? What do you want to know about them? What'd you see? What kind of training did Freshmark do for you when it comes to spills? Does Freshmark have policies about how to handle a spill? What time did you? How long did it take you to clean it? Right? What else? What'd you see? What'd you hear? Are there any police reports or incident reports? Did the ambulance come? Those are all things you're going to want. Freshmark's lawyers, what are some things you're going to want in discovery? Davis? Yeah, you want to see her phone records, exactly. Say it again, Gary. Yeah, yeah. Anybody who's see what the witnesses said. Who were they, and did you take statements from them? Can I have their names so that I can interview them? Good. Smiles.
Was she in a rush? The reason why she had to be on the phone and not paying attention?
You might take Mary's deposition and ask her a lot of these questions. What was going on with you that day, right? What about her claims for lost profits? Autumn?
Would be able to ask for business records.
Yeah.
To see if it's a fair amount.
You could absolutely ask for her business records. Let's see how much she made during prom season the last 3 years. That'd be a very good predictor. Personal financial records. See how bad she needs the money. Seth is thinking like a lawyer here. I like it.
A list of people that work in the shop.
Yeah. Who all was working that day? Good. These are all things that you could do during discovery. Miss Carter.
Age have anything to do with it? Because I have old people fall into a lot worse.
I mean, her age would have something to do with it, but it's in terms of discovery,
It's not really a discovery.
not really a discovery thing. But you're to a broader question: what would age have to do with it? So that's a great question, and it comes into play this way. And I'm not testing you on this now, but we do get into this later in the semester. Negligence is the failure to exercise reasonable care under the circumstances. And what reasonable care looks like is going to depend on the circumstances, but the people too. I would expect Davis, who is and plays college athletics, to be a little bit, the degree of care he would have to use would be less than an old lady would. Or did I say that backwards? What we would expect as reasonable conduct from him is different than the reasonable conduct we'd expect out of her as an elderly lady. Maybe her sight is diminished, and so therefore what is reasonable actions and care for her is different than him, or a baby, or so on and so forth. So yeah, I mean, it would be a factor, but that's how it would play in. All right, so that would be our discovery phase. Those are all excellent suggestions. We go to mediation, your fact pattern says, because we're required to. We go to mediation, we sit down, and Mary sends an offer to the other side. She's asking you guys for $50,000. You guys say we're willing to pay $15,000. Mary's lawyers say no can do. Final offer is 50. Your lawyers say final offer is 15. The mediation ends because the case did not settle. What if the security video showed that Mary was sprinting down the aisle and on her phone? Okay? Freshmark, you've offered $15,000 at mediation. Why would you offer any money at all if you felt like you had the evidence that was a smoking gun slam dunk for your case? Why might you still be willing to pay? Right. That's right, Leandre. You you have some certainty in the outcome. What else?
Maybe it looks better for your image. Yeah.
Maybe it looks better for your image. Maybe part of the settlement is we'll give you 15 and you can't talk about it. Somebody was asking about a non-disclosure agreement. Is that you, Jada? Is that Ms. Miles was?
No, I didn't ask. I was going to ask.
Oh. Did you ask me about that last week? It must have been in the first class. But yeah, maybe Freshmart has something to get out of it, even though they weren't at fault. It's to keep this lady quiet. Why else might you be willing to pay $15,000 when you're not at fault? From a pure business standpoint, bottom line standpoint.
To keep the customer coming back to the store.
It's cheaper than going to court and getting your verdict of not liable. That's right. I could go to court. I can play the video. We can all laugh at Mary, and the jury can come back and say no liability. But that has now cost me because I had to pay my lawyers to do it. And I had to go through the expense and the time and the aggravation of attending trial, attending mediation, attending depositions, all this other stuff. From a pure bottom line standpoint, I might rather just make it go away. Businesses make decisions like that all the time, and that's one of the reasons that you have people that like to sue, just to see if they can get some sort of nuisance value out of it. If you are, let's stay on Freshmart's lawyers for a minute. Let's say that Mary would come to court. Let's say that her offer, she's only asking for $5,000. And you guys are like, well, we would spend $100,000 if we went to trial. We didn't do anything wrong. We've got the evidence to prove it, but we could make it go away for $5,000. But you know what? No. We'd rather spend the $100,000 and go to trial. What's the argument for that?
Makes people not want to do good.
Good. Right, because you're going to have to go back to your board and say, well, we spent $100,000 risking going to trial when we could have gotten out of it for $5,000. But the board might say, you know what, we're sick and tired of getting sued for slip and fall from people and settling it for pennies on the dollar. We're going to send a message that if you sue us, we ain't settling. So yeah, in the long run, it might be more profitable for your company if you deter people from suing you. You don't get known as somebody who will just pay money to make cases go away. So it's certainly possible you can make a business case for not settling as well. All right, we go to trial, and the first thing after we do jury selection is we've got opening arguments. And I told you that is where the attorneys are going to lay out the case. They're going to tell the jury, here's what we think the evidence is going to show. Here's what we expect it's going to show. It would probably be a 30, 45 minute, could be an hour, it could be longer, depending on how much time the court gives you. It would be a speech, basically, or it would be a narrative. The ones I've put for you in the fact pattern, that's one sentence. The lawyer's not going to stand up and say, Freshmart cut corners and Mary paid the price. But that's going to be sort of the theme of the opening statement. Freshmart's opening statement theme is going to be, look, accidents happen. You're going to hear about an accident. We're so sorry that it happened. It is unfortunate. But you'll see from the evidence that we did what we were supposed to do, and she was the one being careless. Okay? Then we're going to proceed to the evidence and testimony part of the trial, where you'll hear from the witnesses, the documents that support the evidence, like medical bills, things like that, will be introduced. Witnesses will be cross-examined. After that is over, then the closing arguments. So in the opening arguments, I told the jury what I thought the evidence was going to show. Closing arguments, I get to say what I think the evidence did show. Ladies and gentlemen of the jury, I told you at the beginning that you are going to see a video that showed that Freshmart didn't do what they were supposed to do. And I showed you that video. And you saw for yourself that olive oil got spilled. You saw the Freshmart employees walking by laughing. You saw the time lapse of 30 minutes from the time it happened to the time they mopped it up. You saw all that. And based on that, you should conclude that they are at fault and they're liable. I recap all the good evidence from my side in my closing argument. Then we get a decision, the verdict from the jury. After we get that, then I could appeal. The loser could appeal if they want to, and it would go on so on and so forth. Again, the purpose of going through that is just to show you how a real life fact pattern would wind its way through the court system using the steps that I laid out for you on Tuesday. What questions do y'all have about that? All right, I want to talk about a couple of current events that are not on your quiz. Let me back up for a second. This fact pattern we just talked about is not on your quiz. I'm not asking you facts from it, but I might ask you things like, what, all of the following are reasons that a company might settle even if they feel they were not at fault or were not going to, they were going to win at trial. Okay, when we talk through those, but I'm not asking you like what happened to Mary and Freshmart and all that. All right, current events. First one is anybody following the Cardi B trial? All right, Miss Miles has only Miss Miles. Did you have? All right, did y'all see it in the news or on TikTok? TikTok, and it went on TikTok because she was being asked questions by the other side's lawyer, and she gave some pretty funny responses, and that's what's been circling around. Really, she made their lawyer look like an idiot. I mean, he didn't know that she was wearing a wig. He's like, your hair was different yesterday than it is today. Like, what's going on with that? She's like, I'm wearing a wig, idiot. So Cardi B, when she was pregnant with her and Offset's first child back in 2018, went to the doctor, to the OBGYN, and nobody knew she was pregnant, and a security guard was filming her. Then they got into it because Cardi B took offense to her filming her. The security guard thought that they should be able to film her. They got a face-to-face screaming match. And the security guard claims that Cardi B scratched her face with her fingernails, caused her injuries, and she's suing Cardi B for $24 million. Cardi B said, not going to happen. We did get into it, but I never touched her. She never touched me. I didn't assault her. I'm not liable for any of her damages. It went to trial. They heard testimony from office staff, people who were there, from Cardi B and from the security guard, and the jury concluded that Cardi B was not liable for any damages. So security guard got nothing. And Cardi B, did y'all see the warning message she sent afterwards too? Yeah, next time somebody sues me like this, I'm going to make them pay. Not really any way she can do that, but basically don't come at me again. So that was a current event. That's a civil case. It was not criminal. It was civil between two citizens. Security guard was just seeking money to compensate her for the damages that she alleged Cardi B caused. Cardi B was found not liable. The other things I want to point out that are current events are that when we talked about sources of law, we focused on statutes and rules made by administrative agencies and case law issued by courts through opinions. I mentioned to you that law could be created through executive orders, but we didn't spend a lot of time on that because it's not as applicable to what we're doing in this class. But President Trump issued 2 executive orders last week that are applicable in these ways. One was that a lot of states, when you get arrested for a crime and then you go see the judge about bail, making bail, which is what you pay to get out while you're waiting on trial. For example, maybe I get a DUI. I go to court the next morning. The judge says, we'll let you out on $10,000 bail. I pay $10,000. I don't have to stay in jail while I'm waiting on trial. I get to be free. Cash bail is the predominant way that bail has always been handled. But some states and jurisdictions have over time changed to non-cash bail. In other words, we're going to let you out, but we're going to put you on an ankle monitor. You don't have to pay anything for your bond. Or we're going to let you out just based on your promise that you won't run, that you won't leave the country, that you will show up for trial. That's called cashless bail. That has become more popular because, for a couple of reasons. One is that there is a school of thought that it disproportionately discriminates against poor people. They don't have the money to post bail that people with money do, and that's not fair. So they should be able to have this option of not posting bail with cash. The other is that if we have poor people who cannot make bail, then they're going to be sitting in the jail, taking up resources, time. It's costing the state money to keep these people in jail who maybe are nonviolent offenders. Cashless bail is not really used for murder and rape and bad things. It's used for lesser things. We'd much rather have these people back out in the community. They're not dangerous in the community. Let's let them out based on their promise to show up at court or put on an ankle monitor so that we don't have to pay for keeping them in jail. President Trump issued an executive order saying any states that use cashless bail, they're not going to get federal funding. Because President Trump can't control state law on bail. That's up to each state. So he couldn't make a decree that says from here on out, cashless bail is illegal, or I ban it. Can't have it anymore. But he could affect the states by saying, I know I can't change your law, but I could withhold money from you if you're going to do things like that. That will get challenged in court as to whether or not he's got the authority to do that, if that exceeds the scope of his authority. That'll play out, but that is something that's going on right now. The second order he issued last week, I'm sorry, go ahead, Aiden.
Executive order that recently got struck down in court.
The tariffs.
The tariffs and the occupation of sending the National Guard to California.
Yeah, so some of the stuff that Trump's done through executive order, which is a bunch of the tariffs that he imposed, and then some of the sending in the National Guard to California. A California court said that was illegal. And then on the tariffs, a court has said that he did not have the authority to issue tariffs. He's appealed that to the Supreme Court. So that is something that's a real life. That'll happen probably, Supreme Court will hear that probably during this semester. So they're going to decide whether or not he had the power through executive order to establish all those tariffs. So thank you for bringing that up. The other one I would throw out to you is that we talked about how the Supreme Court in 1989 had a case on flag burning and whether or not that was protected by free speech, and they decided that it was. There was a 5-4 decision by the Supreme Court in 89. Trump issued an executive order saying he wants the federal government to prosecute anybody that burns the flag. So he's basically challenging the law that the Supreme Court put in place in 89, saying that it was protected by free speech. The Supreme Court can't rule on that, again, until it actually has a case in front of it. So what will happen is somebody will sue saying that Trump's executive order is unconstitutional. That'll get appealed probably all the way up to the Supreme Court. Or they'll find somebody who burned a flag and they'll prosecute them for it. The person who burned the flag's defense will be like, this is not illegal under the Constitution, under precedent, get appealed. And the thinking from the Trump administration is that the makeup of the Supreme Court is different now than it was in 1989, and that he might have a shot of the court deciding it a different way this time. So those are ways that he is challenging the law, trying to make law through executive orders. The tariffs is a great example. He wants the Supreme Court to take another swing at flag burning. And what was the other one? Oh, the cashless bail. They do executive orders all the time. So, I mean, like this is happening on a daily basis. These are just 3 that that I've seen come across the news that I think are interesting and applicable to stuff we've talked about. All right, what's the color of today's lecture? Okay. And your quiz for this week and last week is due Monday, right? It'll be multiple choice, true, false, matching, just like the other. It will cover the lecture outline, any articles you've had to read, anything I've said in class, and your arrow case. All right, see y'all next week. We'll start a new topic. You came in late, come see me so I can make sure I got you. Not yet. It will be today. Thank you. Quiz will be posted later today. All right, Davis, I got you. No, you're not Davis, but I got you, Keyshawn. Thank you, sir. Miss Davis never showed. Miss Davis did show. Awesome. Thank you. You used to sit here, and then Miss Hill sits here, and so I got to get y'all confused. All right, but you weren't here Tuesday, right? Okay. Just want to make sure. All right.
And you're good?
We're good.
Appreciate you.
I don't miss you.
Yeah. Just being chill about it because a lot of professors, they don't get it.
No, I get it. That's fine. You're fine. Well, I will ask you to do me a favor. See if you can reach that clock. Yeah. Hey, Austin, did Mr. Barker never came, right? Okay. I just want to see, I want to see what the deal is. Does it need a battery or? Thank you. Yeah, it's going to. Yep, all I need is a battery. Good. I can't stand not being able to know what time it is. Sweet.